Several important legal issues were considered when the Supreme Court of Ohio conducted oral arguments in August. The court heard 8 cases, including a Trumbull County wastewater disposal company's challenge to the state shutting down its operations. In December 2011, AWMS leased property in Weatherfield Township in Trumbull County near a dam that protects the drinking water of 220,000 people. The Ohio Department of Natural Resources permitted AWMS to operate 2 disposal wells. Shortly after, Ohio started experiencing earthquakes from other disposal wells in eastern Ohio. In 2014, 2 small earthquakes occurred in Trumbull County, and the AWMS wells were suspected of causing it. ODNR suspended the well operations and would only allow them to operate under stricter conditions. AWMS Water Solutions maintained the restrictions put the wells out of business. The 11th District Court of Appeals ruled ODNR owes the company $359,000 in damages for closing the wells for several years. State officials object, arguing the waste site is a public nuisance and a threat to public health.
What do we make of the, for instance, the dam that's within 3 miles of the drilling location and the condition of the dam? How do we treat that? What's your response?
Well, my response to it is, I think, a number of points. First of all, there was no testimony or evidence at trial that any of the microseismic events that were attributable to AWMS had any impact on the dam whatsoever. All they've done is speculate about what could happen in the future. What if speculation is not a nuisance under this court's precedents?
The justices quizzed the state on whether the site is a nuisance, especially since ODNR agreed to allow the wells to reopen.
You gave them permits.
We did give them
and
permits.
They followed the permits, right?
They did follow the permit.
And so is the state creating the earthquake?
They were not doing what the state permitted them to do when they caused the earthquakes. If the division had not ordered them to suspend operations, the earthquakes would have continued to occur and would have likely increased. What the division did here is what you expect the state to do. It looked out for the citizens of Wethersfield Township.
In a second case, Mahad Khalif's vehicle was stolen on a snowy night when he left the engine running and popped into a restaurant for a carry-out drink. When he came back outside, the car was gone, and he ran into the road to chase the thief. The thief turned the SUV around and started driving at Khalif. Khalif shot at his own vehicle, but it didn't stop the driver from getting away. When Khalif reported the theft to police, they charged him with discharging a firearm on or near a prohibited premises. The crime is a misdemeanor unless the shooter created a substantial risk of physical harm to any person or property. In that case, it's a felony. Khalif was indicted for the felony-level discharging firearm crime. A jury was told Khalif was being charged with a felony, but the form signed by the jury when issuing its decision did not specify the level of crime. Khalif was found guilty and sentenced to 45 months in prison. An appeals court found, because the form didn't specify the level, he could only be charged with a misdemeanor. The Franklin County Prosecutor's Office told the Supreme Court the only crime discussed at the trial was a felony, and the jury forms should be interpreted to mean the jury found Khalif guilty of the felony.
The jury found Mr. Khalif guilty of the third-degree felony. He is litigated in the 10th District, whether that was correct or not. The 10th District said it was. That's no longer at issue here. And yet, because the verdict form did not contain those words, the jury's verdict's tossed out the window. He was, at this point, according to the 10th District, he's rightfully convicted only of a first-degree misdemeanor.
We have no record of anybody objecting.
Correct, Your Honor.
Nothing.
Correct.
And so why are we here?
Because, Your Honor, this has been an ongoing issue throughout the state of Ohio. Technically, I believe judges are supposed to create the verdict forms in this case, so if there was an objection below, we would hope the trial court would make the correction.
Khalif's attorney argued the judge and the prosecutor should have filled out the form correctly if they want to charge a person with the higher level of a crime. Because the jury was never asked if Khalif created a substantial risk, he should get the lesser punishment. Justice Hawkins questioned if that creates additional problems.
First of all, you'd agree we could get rid of this problem altogether if judges start putting on their verdict forms the degree of the offense, felony of the second degree, felony of the third degree, that cures all this, correct?
Yes, it does.
Okay. But isn't it true in practicality, defense counsel, trial defense counsel fight tooth and nail to keep that F2, F3 language out of the verdict form because they don't want jurors to know how serious the offense is or what level the offense is?
But the statute says that the court can satisfy the demands of the statute by including a special finding of the additional element, spell out the element that raises the offense to a higher degree.
You can follow these and other cases before the court by visiting our website at supremecourt.ohio.gov and signing up for case activity notifications. The court meets for oral arguments at the Moyer Judicial Center in Columbus. Each session begins at 9 a.m. You can also see them live online at supremecourt.ohio.gov.